You know, I mentioned a minute ago why Article 1 is so weak. Doesn't allege bribery, doesn't allege a quid pro quo, which was the earlier talking point. As weak as the first article is, the second article is orders of magnitude weaker. It is a jaw-droppingly weak article. Now, why is that? First of all, it's worth noting what the second article is. So it's obstruction. So the media folks report, ooh, obstruction, okay, that's bad. Well, wait, hold on a second. It's not obstruction of justice. Obstruction of justice is a crime. That's not what they alleged. Why? Because they can't prove obstruction of justice. Nixon articles alleged obstruction of justice. These articles don't.
Clinton, too.
Clinton, too. Clinton was impeached for obstruction of justice and perjury, both felonies, both federal crimes. This is obstruction of Congress. And the predicate for that is that the White House claimed legal privileges for administration employees. Now, to understand just how ludicrous this is, let's take, for example, John Bolton. John Bolton, National Security Advisor to President Trump. The House Democrats asked him to testify. John Bolton did something very interesting. His lawyer, a guy named Chuck Cooper, my old boss and a good friend, John Bolton's lawyer went to the D.C. District Court. And he said, the House has requested my client to testify, but the White House, the president's asserting executive privilege and instructing him not to. And so John Bolton's lawyer went to the D.C. District Court and said, Judge, tell me what to do. My client will do whatever you tell him to do. Your Honor, I put myself at the mercy of the court. You tell my client the right path to take. You know what the House did next? Said, never mind. And they went away. They didn't even subpoena John Bolton. They simply said, well, if you're going to ask a court what to do, never mind. No, we don't want your testimony. Contrast that, say, to the Nixon impeachment. Nixon impeachment, the House litigated subpoenas, went to the court to enforce subpoenas. Nixon White House asserted all sorts of privileges, executive privilege. Case was litigated, went all the way up to the U.S. Supreme Court. As y'all will recall, the U.S. Supreme Court issued an order to the Nixon White House, hand over the White House tapes. The tapes that the president had made in the Oval Office. It was within, I think, 2 days that Nixon resigned, following the Supreme Court order. That, by the way, is the right way to do it.
And bipartisan.
It was overwhelmingly bipartisan. But in that instance, had the president then defied an order from the Supreme Court to hand over materials after the privilege was litigated, you might well be able to put forward an impeachable count of obstruction of Congress. But they haven't done that. They've simply said the mere fact that you assert a privilege is itself impeachable, without their bothering to issue a subpoena or litigate any of these matters. So it's literally saying a privilege attaches, that is impeachable. By the way, if that is impeachable conduct, all 45 presidents we've had in the United States have committed impeachable conduct. It is an absurd standard to say asserting a privilege is a high crime and misdemeanor. And that's what the second count of the House articles will be.